School of Management Studies, IGNOU presents an audiobook on the course MMPC 003 Business Environment for MBA program. Presenting Block 1, Introduction to Business Environment, Unit 3, Socio-Cultural and Politico-Legal Environment, Part 3. Understanding the legal environment. For describing and analyzing the legal environment of business in India, we present here briefly an overview of some specific socio-economic legislation. We may list these legislations which define the legal environment of business. Company laws. For smooth governance of the business, the company laws play a crucial role. These become the focal laws which impact the commercial environment and subsequent decision-making. These important set of laws are governed by the Ministry of Corporate Affairs through the Companies Act 1956, 2013 and other allied acts, bills and rules. The underlying object is to safeguard the interest of various investors, stakeholders and customers. Two primary bodies ensure its execution, namely the Serious Fraud Investigation Office, that is FIO, and the Competition Commission of India, that is CCI. Different acts which are constituted in this direction are Companies Act 2013, Limited Liability Partnership Act 2008, Insolvency and Bankruptcy Code 2016, Competition Act 2002, Partnership Act 1932, Chartered Accountants Act 1949, Cost and Works Accountant Act 1959, Company Secretaries Act 1980, and Societies Registration Act 1860, etc. It is regulated through National Company Law Tribunal or NCLT, National Financial Reporting Authority, that is NFRA, and the Serious Fraud Investigation Office, that is SFIO. Companies Act 2013. Meant to improve corporate governance and increased accountability, this act aims at improving the ease of doing business in India. It brings forth conceptions like one-person company, small company, dormant company, and corporate social responsibility, etc. It hosts noteworthy modifications in the ways of doing business, including the technologically advanced ways such as improved governance or e-governance, e-management, timely and orderly compliance, legal enforcement, self-disclosure and related norms, role of auditors, mergers and acquisitions, class action suits, and registered valuers. The one-person company. It requires having minimum paid-up capital of INR 1 lakh without any legal obligation for holding annual general meeting, that is AGM. Small company. Other than a public company, it is with a paid-up share capital of maximum 50 lakh rupees or up to 5 crore rupees if prescribed, or its last reported profits is not more than 2 crore rupees and turnover of maximum 20 crore rupees if prescribed. Minimum members for private company. Maximum member heads can be 200 now from the earlier 50. All official communications should bear the full name of contact person, address of a company's registered office, corporate identity number, that is CIN number, which is a 21-digit number allotted by government, telephone number, fax number, email ID, contact website if any. All companies, public or private, under the Companies Act 2013 to comply with the Registrar of Companies, that is ROC, for beginning their business operations. They require submitting the performer with the director's declaration mentioning the subscribers or promoters, with the number of paid-up shares or agreed to be taken by them. The company also requires verifying its registered office with the ROC. The new Companies Act 2013 mandates closing the financial year by 31st of March. Also, the eligible age for managing director or whole-time director is decreased from 25 to 21 years. The Indian company requires constituting a CSR committee and 2% of the average net profits of the last 3 financial years be compulsorily be spent on the CSR activities subjected to fulfillment of certain conditions like the minimum net worth of INR 500 crore or minimum annual turnover of INR 1000 crore or net profit of rupees 5 crore or more. Financial statements are now defined under the Act as comprising of all companies except one-person company, small company and dormant company are now mandatorily required to maintain the following, which may not include the cash flow statement, a balance sheet as at the end of the financial year, a profit and loss account, an income and expenditure account for the financial year as the case may be, cash flow statement for the financial year, a statement of changes in equity if applicable, etc. Capital market. Let us understand the legal framework, structure and working of the Indian capital markets. The Securities Contracts Regulation Act 1956. SCR Act 1956 is the core law which governs the activities of the Indian stock exchanges. Besides safeguarding the investors, it aims to curb unsolicited transactions, dealings of securities and formulate a transparent mechanism. This act recognizes various stock exchanges, memberships and the rules governing thereof, lays down processes for trading activities, including that of security contracts and listing of the securities at the bourses. By definition, and I quote, a stock exchange has been defined as a body of individuals, whether incorporated or not, constituted for the purpose of assisting, regulating or controlling the business of buying, selling or dealing in securities. Unquote. Our country had a separate mechanism to operate the stock exchanges across the nation, but now we have 9 recognized stock exchanges, namely the Bombay Stock Exchange, BSE, Calcutta Stock Exchange, CSE, India International Exchange, India INX, Indian Commodity Exchange Limited, Metropolitan Stock Exchange of India Limited, Multi Commodity Exchange of India MCX, National Commodity and Derivatives Exchange Limited, National Stock Exchange Limited NSE and NSE IFSC Limited. Securities and Exchange Board of India Act 1992. Enacted on 4th of April 1992, the SEBI Act aims at developing the securities market in transparent and disciplined manner for providing investor protection. It attains for providing fairness in dealings, high governance, and institutionalization of standard business practices aimed at fostering efficiencies by an integrated system offering the services at genuine cost, thereby building trust in investors and issuers, both flexible to continuously match the emerging requirements. SEBI is a statutory regulatory body established under this Act. The SEBI board comprises of the chairman, 2 members of finance and law background nominated by the central government, 1 member from the RBI, and 2 more members appointed by the Government of India. They ensure the investor's security in various ways. Cumulatively, the SEBI pursues many functions, which are: number 1, manage the stock exchanges and security markets business operations. Number 2, registering and supervising various capital market entities like stockbrokers, sub-brokers, share transfer agents, bankers to public issues, trustee of trust deeds, registrar to public issues, merchant bankers, underwriters, portfolio managers, investment advisors, and similar intermediaries or self-regulatory organizations having roles in the capital markets. This also includes recording and managing the combined investment schemes like the mutual funds. Number 3, curbing prohibitive, fraudulent, unfair, and unethical trade practices by promoting investors' education, training, and awareness initiatives of intermediaries and customers. Number 4, prohibiting insider trading. It also regulates the acquisition of shares, mergers, and takeovers. And number 5, periodic audits of the bourses and related intermediaries, seeking information, inspections, inquiry matters, etc. The board may levy underlying fee or similar charge for it. Besides, the board carries research for all the mentioned purposes to coordinate and regulate the control over the activities performed. Over-the-Counter Exchange of India, that is OTCEI. OTCEI was established in 1990, started functioning in 1992 as an electronic stock exchange without a proper trading floor. The exchange was established with an objective of supporting enterprising promoters for securing cost-effective project finance besides offering its investors with transparent transaction systems. It went further in the capital markets by providing technologically enabled mechanisms like screen-based nationwide trading, market making, and scriptless trading. The OTCI performs many functions which are: Number 1. Extend services to small companies for generating cost-effective funds from the capital market. Number 2. Provide easy access for the small investors to the capital market, also facilitating investors by boosting their confidence. And number 3. Smooth, transparent investor grievance redressal mechanism even to the far geographical areas and providing much required liquidity. Foreign Exchange Management Act, that is FEMA. Under the guidance from the central government, which articulates the foreign trade policy, the central bank, that is the Reserve Bank of India, carries the responsibility of implementing it by deploying the Foreign Exchange Control Act, known as Foreign Exchange Regulation Act 1947. This act stood updated in the year 1974 by FERA. Therefore, in 1991, the globalization saw the requirement of newer policy measures, and thus FERA made way for the Foreign Exchange Management Act, FEMA 1999. It carries significance in the viewpoint of foreign trade and foreign exchange. It is applicable on any business entity involving an Indian resident. Significant features of FEMA are: Number 1. Limitations concerning assets owned by the non-residents and transactions pertaining to bringing in and taking out the currency and precious metals stood abolished. Limitation pertaining to the acquisitions of immovable property and its holding, etc. in India also has been done away with. Number 2. Hospitality to non-residents on Indian visits stood allowed. On similar lines, the Indian residents visiting outside India for related activities stood allowed too. Number 3. Lowered restrictions for holding the immovable property outside India. And number 4. Cases pertaining to seeking funds, deposits or loans in India from the Indian residents stand simplified. Also, foreign nationals need not seek approval for taking up employment in India. Appointment of people as agents, advisors on technical management profiles relaxed. The new act encourages setting up of branch offices, Malaysian offices encouraged, and foreign travel permissions have been relaxed. This act aims at consolidating and amending the legal forex-related impediments to promote international business and external trade, besides regulating the Indian forex market. The Sikh Industrial Companies Special Provisions Act 1985, that is SICA 1985. Due to the rapid industrialization clubbed with the multinational corporations influencing the business environments in India, there was a growing need for institutionalizing an act to govern the menace of growing industrial sickness. On one hand, the government puts efforts to promote the industrial setups, and on the contrary, when these setups are graded sick, it causes multiple damage in terms of employment, production loss, locking of funds, etc. So reviving these companies to salvage and monetize the assets become important. Thus, the Sikh Industrial Companies Special Provisions Act 1985 SICA was legislated for appropriate recognition of Sikh and potentially Sikh companies. In the same direction, the SICA proposed the constitution of the Board for Industrial and Financial Reconstruction, that is BIFR, for identifying the industrial sickness reasons, its extent, and putting forward remedial measures to limit the sickness. Besides, it aims to contain this sickness and take measures to revive these industrial units. From 1st December 2016, the SICA stood repealed by the Sikh Industrial Companies Special Provisions Repeal Act 2003, that is Repeal Act, thereby diluting the BIFR and its constituent or related bodies. SICA and its repeal. Broadly, the functioning of BIFR and AAIFR, that is Appellate Authority for Industrial and Financial Reconstruction, was not only much time-consuming but stood uncertain too. It was therefore decided to solve the ambiguities and single entity be formed to handle and dispose all such company-related matters. Thus, the National Company Law Tribunal, that is NCLT, and the National Company Law Appellate Tribunal, that is NCLAT, were formed under the guidelines of the Companies Act 2013. The NCLT works on the company management issues, and it got further strengthened by the Insolvency and Bankruptcy Code 2016, thus obsoleting the BIFR and AAIFR besides the pending proceedings only. The objectives of SICA are: Number 1. Identification and timely perusal of sick and potentially sick business entities. Number 2. Initiation of the redressal mechanism for fast resolvence, either preventive or remedial process by the expert panel. Number 3. Accelerate the desired corrective actions. And number 4. Apprehend, review, and coordinate for future scope. With the increasing complexities in the politico-legal business environments, SICA became obsolete in combating corporate sickness. The Insolvency and Bankruptcy Board of India. The board, established on 1st October 2016 under the Insolvency and Bankruptcy Code 2016, is one of the most important pillars in the corporate business system, which relates to the various laws pertaining to reorganization, restructuring, insolvency of the company, and resolution pertaining to corporate board and stakeholders, partnership firms on scheduled timelines. It aims at asset maximization both in quality and quantity, encouraging entrepreneurship, leveraging assets, etc. Being a one-of-its-kind entity, it strives to aim at business governance by enhancing its processes. It oversees the insolvency professionals, insolvency professional agencies, insolvency professional entities, and information utilities by regularly administering the processes pertaining to corporate insolvency resolution, corporate liquidation, individual insolvency resolution, and individual bankruptcy. It has recently been tasked to promote and manage corporate insolvencies. The function of the Chapter 19, Section 253 to 269 in Companies Act 2013 particularly pertains to the revitalization of the SIC units. In the initiatives towards ease of doing business, 27 sections have been amended in the Companies Amendment Act 2017, including redefining the associate company by bringing in the joint venture perspective. The voting powers of subsidiary company was also changed. Disclosures by the companies at the time of prospectus to CBI were added too. Other modifications involved loans, audits, and qualifications and powers of the directors. Insolvency and Bankruptcy Code 2016. The competitive business environments, particularly resulting from the evolving technologies and increasing competition, have served to be an enabler for new businesses, but on the other hand, the weaker ones increasingly demonstrated tendencies towards sickness, thus seeking amendments in repealing the SICA Repeal Act. This was executed by substituting the Section 4, Subclause B, and the following subclause shall be substituted, namely, Subclause B, on such date as may be notified by the central government in this behalf, Any appeal preferred to the appellate authority or any reference made or inquiry pending to or before the board or any proceeding of whatever nature pending before the appellate authority or the board under the Sikh Industrial Companies Special Provisions Act 1985 shall stand abated, provided that a company in respect of which such appeal or reference or inquiry stands abated under this clause may make reference to the National Company Law Tribunal under the Insolvency and Bankruptcy Code 2016 within 180 days from the commencement of the Insolvency and Bankruptcy Code 2016 in accordance with the provisions of the Insolvency and Bankruptcy Code 2016. Provided further that no fee shall be payable for making such reference under Insolvency and Bankruptcy Code 2016 by a company whose appeal or reference or inquiry stands abated under this clause. The provisions of the code dealing with the amendment to the SICA Repeal Act came into force from November 1, 2016. However, the Ministry has appointed December 1, 2016 as the date on which the provisions of the SICA Repeal Act shall come into force. A question may arise as to which date shall be considered, that is November 1, 2016 or December 1, 2016. On careful reading, one may note that Clause B of Section 4 states as, and I quote, "The central government wide notification dated November 25, 2016 has notified the provisions of the SICA Repeal Act. Therefore, any reference made to BIFR, any inquiry pending before BIFR, any appeal preferred to AAIFR or any proceedings pending before BIFR or AAIFR shall automatically stand abated with effect from December 1, 2016. Defining a Sikh company. The Sikh company thus is defined as where on a demand by the secured creditors of a company representing 50% or more of its outstanding amount of debt, the company has failed to pay the debt within a period of 30 days of the service of the notice of demand or to secure or compound it to the reasonable satisfaction of the creditors. Any secured creditor may file an application to the tribunal in the prescribed manner enclosing relevant evidence for such default, non-repayment or failure to offer security or compound it for a determination that the company be declared as a Sikh company. Monopolies and Restrictive Trade Practices, that is MRTP Act 1969. The MRTP Act has its roots arising out of the directive principles of state policy embodied in the Constitution of India, Article 39B and C, which says to ensure, number 1, that the ownership and control and material resources of the community are so distributed as best to subserve the common good, and number 2, that the operation of the economic system does not result in the concentration of wealth and means of production to the common detriment. Monopolies generally benefit a few but harm many as they tend restricting the competition, mainly controlling the prices of commodities in the market, thereby resulting manipulation by a few. The MRTP Amendment Act 1991 has omitted provisions regarding the central government's permission for substantial expansion, establishment of a new undertaking, mergers, takeovers, etc. Establishments, however big or small, are now free to expand or establish new undertakings or effect mergers. Monopolistic trade practices. Any trade practice which leads or is likely to lead any of the mentioned effects is regarded as a monopolistic trade practice. These effects are: number 1, unreasonably high price; number 2, unreasonably high cost of the production of goods or the provision of services; number 3, unreasonably high profits; number 4, prevention or reduction of competition; number 5, limited technical development; number 6, limited capital investment; and number 7, deterioration in the quality of goods. Restrictive trade practices. The term restrictive trade practice is defined to mean a trade practice which has or may have the effect of preventing, distorting, or restricting competition in any manner and in particular if it, number 1, tends to obstruct the flow of capital or resources into the stream of production, or number 2, tends to bring about manipulation of prices or conditions of delivery, or to affect the flow of supplies in the market relating to goods or services in such a manner so as to impose on the consumers unjustified cost or restrictions. Every agreement falling within the one or more of the certain categories is deemed to be an agreement relating to restrictive trade practices and is subjected to registration under the Act. These categories are: number 1, refusal to deal and or boycott; number 2, tie-up sales and exclusive dealing and or discriminatory dealings or territorial restriction or restrictions or withholding of output or supply; number 3, concert in prices and terms and conditions of purchase or sale; number 4, resale price maintenance and controlling manufacturing process; and number 5, agreement having the effect of eliminating competition or competitors, etc. Unfair trade practices. They have been defined as per the Act to mean a trade practice which, for the purpose of promoting sales, use or supply of any goods or for the provision of any services, adopts any unfair method or deceptive practice, including: number 1, bargain sale; number 2, bait and switch selling; number 3, offering gift or prizes in promotional contest and not providing them, etc. Consumer Protection Act 1986. Our country has been a large market and has attracted traders from the business and commercial perspective. Owing to the large geographical spread and low level of education amongst the people, the fraudulent practices were witnessed, and in order to curb them, many legislations were enforced, like the Sale of Goods Act 1930, Essential Commodities Act 1955, the Prevention of Food Adulteration Act 1954, Prevention of Black Marketing and Maintenance of Supplies of Essential Commodities Act 1980, Standards of Weights and Measures Act 1956, Agricultural Products Grading and Marketing Act, that is Agmark 1937, Indian Standards Institution Certification Act 1952, MRTP Act 1969, etc. MRTP Act, though, was able to put a check on the rapidly increasing consumer fraudulent practices. The need for an inclusive consumer protection legislation was much required, thus making way for the Consumer Protection Act 1986 for providing fast and cheap redressal to consumer grievances. The Act recognizes 6 rights of consumers, namely: number 1, right to safety. That is, the right to be protected against the marketing of goods and services which are hazardous to life and property. Number 2, right to be informed. That is, to be informed about the quality, quantity, potency, purity, standard, and price of goods or services, as the case may be, so as to protect the consumer against unfair trade practices. Number 3, right to choose. That is, the right of access to a variety of goods and services at competitive prices. In case of monopolies, say railways, telephones, etc., it means right to be assured of satisfactory quality and service at a fair price. Number 4, right to be heard. That is, the consumer's interest will receive due consideration at appropriate forums. It also includes the right to be represented in various forums formed to consider consumers' welfare. Number 5, right to seek redressal. That is, the right to seek redressal against unfair practices or restrictive trade practices or unscrupulous exploitation of consumers. And number 6, right to consume education. That is, the right to acquire the knowledge and skill to be an informed consumer. Competition Commission of India. The informal activity of regulating the market rivalry by business houses is traditional. However, it surfaced in the year 2002 when the government recognized the need to regulate this market competition, and thus the Monopolies and Restrictive Trade Practices Act of 1969 was repealed, thereby making way for the Competition Act of 2002. This act was subsequently amended in 2007 and 2009. The Act proposes for a legitimate framework be articulated and practiced in the competition policies, thereby curbing the anti-competitive practices with punitive action. CCI was formed under this act, which makes way for providing an environmental culture imbibed with free, fair and healthy market competition, clubbed with trade freedom and customer and societal orientation. This forms the three structural pillars to deter the unhealthy competition, namely anti-competitive agreements, their combination, meanings, and abuse of dominance. The Commission stands empowered to levy penalty on the offenders amounting up to 10% of the average turnover of the company during the last 3 financial years upon all offending enterprises and/or alleged individuals. Further, the entities found involved in cartelization by the Commission can be penalized. For the higher amount of up to 3 times of the profit for the found period or 10% of the turnover for the period in the agreement. The Environment Protection Act 1986. The Indian Constitution mentions Indian citizens compassionately protecting and improving the natural environment, including forest, lakes, rivers, and wildlife. In this direction, the Environment Protection Act 1986 envisaged with 2 complementing acts, namely the Water Prevention and Control of Pollution Act 1974 and Air Prevention and Control of Pollution Act 1981, have an objective to lay down a framework for environmental protection and its subsequent preservation. The components of the natural environment comprise of water, air, and land, besides their interactive relationships with humans and other living elements and the ecosystem. This act enables the central government with certain powers to protect and improve the environmental quality by curbing and abating the environmental pollution. This involves constituting and delegating authoritative office to achieve the mentioned objectives. A few other legislations. We have understood by now that the legally structured environment stands robust enough, and we have gone through certain laws and enactments influencing the said environment. Besides them, there are certain more legislations which impact the Indian business environment in various other conditional circumstances. Like, number 1, the Essential Commodities Amendment Act 2020. It encapsulates tough penal action for the alleged entities or people. The Act proposes stringent legal framework for antisocial elements like hoarders, profiteers, smugglers, and black marketeers. Number 2, the Trade Markets Act 1999. Number 3, the Patents Amendment Act 2005. And number 4, the Urban Land Sealing and Regulation Act 1976. Now let's summarize the unit. Socio-cultural environment consists of social and cultural elements affecting the growth and development of an economy. They include knowledge, beliefs, values, morals, behavior, attitudes, religion, ethnicity, and language. Politico-legal environment is a combination of political environment and legal environment. It consists of laws, governments, statutory bodies, judiciary, executive council, and legislature. Politico-legal environment changes with each political development in the country. Sometimes, legal reforms are based on the changes in the ideologies of the ruling government. These elements can lead to either threat or opportunities for a business organization. Any organization desiring to operate in a country need to undertake socio-cultural as well as politico-legal elements into consideration before planning a strategy. The Ministry of Commerce and Industry promulgates a policy support to the businesses besides playing a pivotal role in ease of doing business initiatives. Other legal and policy support extended by law enactments like the Competition Commission of India, SICA, Consumer Protection Act, Environment Protection Act bolsters the business functions in other perspectives arising from time to time. You were listening to the audiobook by the School of Management Studies IGNOU for MBA program. Course code MMPC 002 Human Resource Management. Course Coordinator Professor Nayantara Padhi from School of Management Studies, IGNOU. Voiceover by Harpreet Kaur. Edited by Ruchi Sharma. Program assisted by Tarannum Jahan. Program produced by Dr. Manoj Kumar Singh. This program was brought to you by Electronic Media Production Center of Indira Gandhi National Open University.